Now there is a law called Stamp Act in India, which speaks about the stamp duty that is payable on instruments that are done or executed during making some transactions. So what is an instrument? Suppose you execute a sale deed. That is called an instrument. You have to pay some stamp duty to the government. What is stamp duty? It is simply a tax in the form of stamps. So they are collected by the government whenever you are doing the transaction. There are two kinds of transactions that are operating in the market. One is one which must be compulsorily registered. One you can optionally registered. If it has to be compulsorily registered or optionally registered, government fixes some stamp duty because government wants revenue to run the government. You have to pay the stamp duty by purchasing the stamps. That money goes to the treasury of the government and that will be used by the government for public purpose. Now if you don't pay the stamp duty as per the Stamp Act, if you don't pay the stamp duty, then if you are performing the transaction in the sub-registrar's office, they will reject the transaction. But there may be instances when you have an option not to go to the sub-registrar's office and register the sale deed or register the transaction. I will give you two examples for this. Imagine you are purchasing some property. Now law says whenever you are purchasing an immovable property, you have to register the agreement of sale. Now many people don't register the agreement of sale. They execute the agreement of sale on 100 rupees stamp paper and directly after 45 days they go and execute the sale deed. Now there is nothing wrong in it because agreement of sale, the amount that is paid in the agreement of sale as a stamp duty, that is redeemable. That will be reduced when you are executing the sale deed. Suppose for example, the stamp duty on a sale deed is 10%. For agreement of sale it will be 5%. Now that 5% is reduced when you are performing the sale deed. So here they don't register the agreement of sale. And one of the open reasons for not registering the agreement of sale is the black money is written in the agreement of sale. But registration is done only for the white amount. Generally speaking, government decided market value rate for immovable properties is always less than the current market price. So therefore, black amount is written in the agreement of sale and therefore majority of the people do not want to go to the sub-registrar's office and register it. Now there is a price for violation of the law. I'll come to that in a little while. Now this is one type of transaction where you are evading stamp duty by not registering the agreement of sale. Now let us consider another example. You are selling some property to somebody and you are doing it by way of a gift deed or you are doing it by way of a will deed. Now you are seeking the seller or the vendor of the property to execute a gift deed in your favor or a will deed in your favor just to evade the stamp duty. Now you are playing fraud. Now because the general format for the gifts is out of love and affection. The stamp duty for gift deeds is less when compared to sale deeds. So here if you are playing fraud on the government for evading the stamp duty, here you are completing the transaction. Unlike in the agreement of sale, transaction is not getting completed. Transaction is only partial. But in a sale deed issue, the transaction is completed and instead of executing the sale deed, you are executing the gift deed to evade the stamp duty. Here you are playing fraud. Now as per section 40 of the Stamp Act, the punishment that government imposes when you are trying to evade stamp duty using any of the examples, two examples which I refer to right now, is 10 times. That is, if you evade a stamp duty of 1 lakh, government has the power to impose a penalty of around 10 lakhs. Discretionary. If it thinks fit, government can impose a penalty of around 10 lakhs. Collector. Generally it is done by the collector, district collector. Now, district collector was given absolute discretion to impose up to 10 times if he thinks fit. This is the expression that is used in the Stamp Act. Now many district collectors can misuse this provision, and it is a breeding ground for corruption. Suppose if the government authority is corrupted, he may impose less penalty. Instead of 10 times, he may impose only 1 time. And if you don't pay the penalty, if you don't pay the bribe, he may impose 10 times. So the discretionary power, if at all the legislature or the government has a discretionary power, it is a breeding ground for corruption. Now Supreme Court has given some guidelines. Supreme Court clarified that 10 times is the maximum penalty. If at all you wanted to impose maximum penalty, it should be imposed only in the extreme cases. And what are the extreme cases? The extreme cases are fraud. So therefore, if there is an element of fraud, if the collector decides that fraud is an element in evading the stamp duty, then only 10 times penalty must be imposed. Other circumstances, like if the citizen is not having money, there is a financial problems, at that point of time he may not be having the money. Therefore, if he is evading stamp duty, or else the conduct of the party, the intention of the party, or sometimes like in the earlier example where I referred to an agreement of sale, based on agreement of sale, instead of registering the agreement of sale, he did not, he went directly for the sale deed without registering the agreement of sale. There is no loss for the government. Now if the sale fails, agreement of sale comes to court. At that point of time, the collector must not charge 10 times penalty, because there is no element of fraud. It is only based on the conduct and the intention of the party. Here it is different, fraud is different. In one example, instead of executing a sale deed, a gift deed was executed or a will deed was executed. Therefore, it was a pure fraud played on the government. It is an extreme case. Therefore, 10 times penalty is applicable there. In another, in an agreement of sale case, there is no fraud. They simply, sometimes white amount is also written in the agreement of sale. They don't go to the sub-registrar's office for hundreds of reasons, because once agreement of sale is registered, the seller is locked in the transaction. If it is unregistered, they can just tear it in their home, and it is quite a lot of freedom. If it is registered agreement of sale, it has to be cancelled, and therefore also generally agreement of sale is not registered. But here there is no intention of fraud. Here the intention is different. Intention is as a deterrence, as a precaution. Therefore, it was not registered. So this discretion, the reasoning has to be given when 10 times penalty or 1 time penalty is charged by the government. This is Supreme Court clarified in the recent decision, which is in the description box. Kindly go through it. And if you have unregistered documents in your hand, don't worry. You can do an unregistered transaction also. There could be hundreds of reasons. But see that fraud is not there, because if fraud is played on the government, then you will be charged 10 times. Otherwise, you can question this in the court for reduction of the stamp duty. Okay, thank you. Thanks for watching. If you have any doubts, kindly comment.